Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammi. I am Executive Director and Vice President for Legal Studies at the Washington Legal Foundation. For those of you not familiar with the foundation, we are in our 47th year of free enterprise advocacy and education through amicus filings in the federal and state courts, regulatory filings at the federal level, publications and programs such as this one. If you have any interest in learning more about the foundation, we are at WLF.org. So private enforcement of federal law and laws and regulations has been an area of significance for WLF over our entire existence. In addition to the due process and delegation of authority issues, we're concerned with the financial incentives that drive private enforcement. For example, relators that file QTAM actions under the False Claims Act can recover millions from successful suits and settlements. Environmental activists and their lawyers not only earn fees from citizen suits, but the suits also act as potent fundraising tools for nonprofit organizations. As we well know, the nonprofits need to keep donations flowing and certainly lead to suits of questionable environmental value. When filed against the government, citizen suits can tie up valuable time and taxpayer resources or even change how agencies enforce rules. That's a long-winded way of saying that our topic today is an extremely important one, both for those who value fair and balanced law enforcement and for the private enterprises that are on the receiving end of citizen suits. With EPA and other agencies under new management starting January 20th of next year, citizen suit filings will inevitably be on the uptick. We put this final webinar of 2024 together to address recent trends and help our audience prepare for the expected uptick. Joining us today are two partners from ArentFox Schiff. First, I'll introduce Michael Showalter, who's a partner in the New York and Chicago offices of the firm. He's a litigator focusing on business and public policy disputes. While much of his work involves disputes arising under environmental statutes such as CERCLA, RCRA, Clean Air Act, and the Clean Water Act, Mike has represented parties in civil rights, commercial, class action, toxic tort, and regulatory litigation in courts throughout the United States. Bradley Rochlen is also a partner at ArentFox, practicing in the firm's Chicago office. Brad assists clients in prosecuting and defending Superfund cases, RCRA cases, and private cost recovery cases at some of the largest contaminated sites in the country. He has significant experience in resolving Clean Water Act and toxic tort disputes. Just want to let you know that this program is being recorded. If you have any questions, please use the Q&A function in the Zoom webinar toolbar. And we'll get started with a question for Brad. So how many federal environmental laws include private enforcement provisions, and which laws do private plaintiffs most often enforce?
Well, first of all, thank you for having us. We're excited to be here. Like any good big firm environmental lawyer, my first experience with citizen suits came from getting sued by environmental activists. And we can talk about some of that as we go on. But also one of the interesting things you'll find is that the plaintiff doesn't necessarily need to be an environmental activist group. It can be the same companies that get sued under citizen suits can actually turn around and use those as a litigation tool, and we can talk about that. But the short answer is all of them. In federal environmental laws, basically all have environmental citizen suit provisions. Clean Water Act, most notably, that's usually that's the primary one. But CERCLA, RCRA, and we deal. Me personally, I wouldn't speak for Mike. Mostly Clean Water Act and RCRA are the two main ones that get used, and they are used most often to step in for what they see as a big hole in government enforcement. If the government is not enforcing, a release, if they see a release, if the lake near their house is smelling, or if they see a sheen of oil on it, that's a prime place they might go. If they see dumping, illegal or otherwise, on a property, they might sue under RCRA, so they will sue under. Well, they will send a notice letter. We'll talk about that, but they will sue under the citizen suit because the government is not doing what they see as their job of enforcing the federal laws. So they are basically in place of the government.
So, Mike, do these provisions empower private parties to sue government entities as well, like EPA or other agencies?
So They can. So there's two different kinds of provisions, right? You could have provisions which relate to enforcing the law, and Brad talked about those before. And then you can also have provisions about how to shape the law. So private parties tend to use both. Occasionally, they'll use them in combination. There's pretty good case law saying the provisions that are intended to enforce the law can't be used to shape the law. So you can end up in fights because sometimes the provisions used to enforce the law are often available in district courts, where the provisions used to shape the law often have sort of venue-related provisions, which often involve challenges being filed in courts of appeals. So, when we think about cases like a lot of the big air-related cases, like West Virginia versus EPA, those sort of challenges almost always begin in one or many of the courts of appeals, but there are provisions like that. And beyond those, kind of outside of traditional provisions, you also see occasionally people using petition provisions, which are in many of the federal environmental statutes. You say, hey, EPA, you didn't do this right. We're going to file a petition to have you change how you regulate, whatever substance. And then you can end up in a situation where you can use even provisions of the APA to kind of say you didn't respond to this petition correctly. And people have also tried to use kind of quasi-constitutional ways to change how agencies have enforced or interpreted the law. Kind of the lead case in the United States about that lately has been the Juliana case, which is super interesting in that it was filed by an NGO, I think under the belief that nothing would ever happen. It was more of a PR stunt, but it has percolated through various federal courts now, I think for about 8 years. So they can have pretty long kind of lasting effects.
So how generally, like, do private parties identify opportunities? I mean, one can imagine that given the many data transparency mandates and federal environmental laws, groups and individuals don't have to look much beyond government websites at times.
In terms of private enforcement, absolutely not. I mean, people are kind of stepping back about 10 years. There's an idea that people could go out and gather data for themselves. And there was great fear in industry that people would go out with sensors and collect data. And for a time, maybe 10 years ago, people thought that this is going to happen. This is going to be, we're going to have like fights about data in courts. But increasingly, that's not what's happening. What people are doing with the rise of the internet and with state and federal agencies pretty routinely now putting data or making data available on the internet, people are getting interns to go on and scour the internet and look for people's permit-related filings or enforcement-related filings, and been suing when they don't feel like the government is doing enough. We recently wrapped one up under California has a statute or a mechanism called Prop 65, and somebody went and found state mandated cleanup documents and challenged our client because the regulator was engaged until it wasn't. And it's what people are doing. People are looking for data, and increasingly, when agencies get engaged with a site or with a regulator, they're requiring data to be publicly available. So the data is almost always out there. Certain states, it's better than others. California, for instance, New York, a lot of the kind of classically blue states have pretty advanced tools to go out and find private party data. And if you have a lot of data out there and a legion of ideologically motivated interns, you can fan people to sue.
Brad, you had mentioned the need to file a notice first. Can you explain that and sort of generally the process of how citizen suits work?
Absolutely. So as I said, the purpose of the citizen suit is to step into the place of the government. So before you can just run into federal court, you have to let not only the party that you think is in violation know, but also the government. So we have all of the provisions have a notice part to it. It's usually 60 days. There's some wiggle room there. Under RCRA, for example, it's 90 days if you're claiming imminent and substantial endangerment. But let's talk generally, it's 60 days. And why is that? So you need to let the party know what you think they're doing wrong and give them a chance to say, okay, you're right, let me go fix it. Or you need to get the government a chance to say, you know what, you're right, we should be doing that. So we're going to jump in and start enforcing. And if they if though one of those two things happens in the 60 days, great, everybody's happy, although the party spending lots of money probably isn't as happy, but the citizen suit necessity goes away and would be overtaken by the federal action or by the voluntary action if they can negotiate, okay, we're going to go do what we need to do, and that's enough to move on. And 60 days is not a lot of time, especially depending on when you file it. You know, if you were to file it today, you've got the Christmas holidays coming up. What can happen? So there's obviously some gamesmanship that can happen there if a advocacy group really wants their day in court and they want to get there, you know, that they can play it. But the goal as it's done is to have the party make very clear what needs to happen, where the violation is, what the violation is, and you know what needs to be done about it. The party also has to disclose who they are, right? They need to have standing to sue. You can't just have some random person across the country in California sue in New York, or someone in Nebraska sue in Michigan, right? You have to have a person or a group that is actually affected, even if it's potential effect, but it has to be a real injury, or you know, or a potential injury for. And the case law is pretty broad here. What that means, right? You don't have to have a broken leg. You can. The example I gave earlier, for example, the sheen in the lake. You have an oil sheen on top of a lake. And if that's happening, and I like to walk my dog next to that lake, I don't like seeing that oil. That ruins my enjoyment of nature. That's standing. I live nearby. I walk by that lake. I am a real plaintiff there. So you have to disclose all these things. Theoretically, there will be some communication back and forth. I can tell you, we had a case out in California where an environmental advocacy group sued our client who had wood-treated poles, and they were treated with contamination with a preservative so that they didn't rot. And they were saying that that was a violation because that became a hazardous waste in the environment. And they filed their notice, and they gave us their name and their phone number. So we called them. So what is it you want to talk about? They wouldn't return our phone calls until after 60 days. We couldn't even tell what exactly they wanted us to do. They really want us to pull every single pole in the territory. And so they got beyond this notice provision by just ignoring us. And that's, you know, that's kind of how the entire litigation went. Mike and I spent quite a few years on that one, and ended it rather successfully. But it's another way to game the system. So once you have the notice and you have the standing of a plaintiff, you can then, and you get beyond the 60 days or the 90 days, you can then take it to court, and you become basically like the government trying to enforce the statute. And it's the same rules and regulations that you're suing under as if you were the government itself.
So what happens if the 60 days go by, the private plaintiff files suit, and then the government comes in and says, okay, we'll take care of this? Does that become a battle between the government and the citizens group then, in terms of whether they can continue with their lawsuit?
That is a very good question. And there's the law and there's the practicality. Under the law, once you have your lawsuit on file, if there is not an actual enforcement action going, technically the lawsuit can continue. And why would it continue? Well, one, if you don't trust that particular government entity is going to do the right thing. Or two, and this is more common, all of these statutes have attorney fee provisions. So they are looking to get both a foot in the door so that they can monitor the work that's actually being done. And Mike mentioned the data and all of that. But two, they want to get paid. A lot of these environmental advocacy groups, this is their funding mechanism, you know, donations and everything. But that by getting these types of agreements, more often than not, you're going to say the government's doing this, you'll go into court, you know, there'll be a settlement, right? You're not going to theoretically fight forever on this when the work is already being done. But technically, it can.
Thanks, Brad. So, sorry, Mike, you wanted to add something?
Yeah, there's one exception. So in terms of sheer number, the most citizen suits are filed by groups behaving as Brad just described. It's profit motivated attorneys with some degree of ideological interest. But there's another group of folks who file a lot of them too, and they're NGOs, right? We've been through now beyond coal, beyond petroleum, and we're moving on to beyond plastic. And those groups that file those cases, so groups like Sierra Club and NRDC, they behave differently because their purpose isn't even necessarily winning any particular case. It's using sort of two things. One is the public advocacy forum that's generated by the cases, but also that they're trying to increase transaction costs to businesses, right? Businesses need to do things within particular periods of time, and slowing down projects or potentially killing their funding to them, can get them, at least theoretically, some wins that they can't get through other more traditional forms of advocacy. And in those cases, if you have a party who usually files Prop 65 cases suing you about, discharges from your scrap metal site in California, that's going to proceed one way. But if Sierra Club's Beyond Coal campaign is engaged against your power plant or your CCS project, it's likely to proceed a different one because their goals aren't the same thing. They're not as motivated by profit because they get a ton of money from philanthropies and other things to engage in advocacy like this. And they frankly just don't need your money, and they don't even need a win in the case.
So because we're holding this program kind of in the context of a forthcoming changeover in executive branch control, Mike, you give us a general idea about the frequency of citizen suits during the Biden administration over the past 4 years?
In terms of number, I think it's maintained relatively consistent numbers from what we have seen in past administrations. The Biden administration was really engaged in addressing environmental issues. Environmental justice was sort of a single-minded focus. We saw major legislation in the form of the Inflation Reduction Act really kind of providing a ton of funding for green energy. And we saw a lot of work in the Biden administration trying to engage, maybe not before EPA, but in other parts of government with climate change and sort of reporting obligations. So you had an administration which was engaged kind of on the green side of these issues, but people still weren't completely satisfied with what is happening. And as Brad alluded to before, what oftentimes you see citizens who's filed in terms of the ones which are more difficult, you see people frustrated about what the government's agenda is. Climate, it's an interesting issue. You see a lot of public concern, you see a lot of business concern, but what we have are statutes which haven't been really changed to address it. And we've seen a lot of creativity in the climate space, sometimes using citizen suit mechanisms, sometimes using tort litigation, sometimes using private actors to push an agenda that they're just not seeing the results they want from other processes, and that litigation is continued. Environmental justice was a Biden administration priority, but when the Biden administration pushed different things in ways which were different than some NGO groups might want, they sued too. But the trends have remained relatively consistently, but we have started to see some changes where you're seeing other aspects of deregulation or courts kind of moving off in a different direction start to play in this thing. But statistically, the number of cases appear to be the same, but we started to see new issues bubble up. A little bit of climate, a little bit of plastic-related issues, and then emerging contaminants like PFAS. We started to see them be drivers of some of this litigation too.
Were there any citizen suit trends during the first Trump administration that might inform what to expect from private litigants in the next 4 years?
There were a ton. Statistically, between 2017 and 2020, we saw a total of 566 cases get filed. A lot of those were Clean Water Act cases, as Brad indicated. Those have been kind of a big thing. You see a lot of them in California. You see a lot of them in the state of Washington. You see a lot of them in West Virginia, where I'm from, usually oftentimes tied to coal-related issues. Over the course of the Trump administration, we started to see more cases get filed later. So in 2018, there were 75 suits. In 2020, toward the end of the Trump administration, there were 146 suits. So people, I think, started to get these efforts off the ground. And then, kind of simultaneously with these, we saw a ton of challenges kind of across the government using kind of any mechanism available to challenge, to shape regulations, private parties trying to wade into regulatory fights using courts, and that absolutely skyrocketed under the first Trump administration. And it seems relatively reasonable to expect that that's going to happen here too.
I would be
How about, I'm sorry, Brad, go ahead.
I would be surprised if it took as long as last time, since we had Trump 1. I don't think they're going to wait 2 years to see. I think they're going to jump right in. So I think you're going to see those numbers go up right away.
So do either of you anticipate an increase in citizen suits against federal agencies seeking to compel certain actions? Can regulated entities, can they play any role in those?
I think we're going to see a lot. I think people are, things go through phases, right? And there's almost a seasonality now to how administrations change over. We're going to see some actions straight out the gate involving executive orders. We're going to see some actions straight out the gate, probably because you have both houses of Congress and the presidency in the same hands. The Congressional Review Act is likely to engage in some regulations. And sure, we're going to have a lot of litigation for people to file. Or not to file, to watch and participate in and everything else. I think compared to past administrations, I think it is fairly likely that a lot of government by the judiciary is going to feature in pretty compellingly in the next 4 years. And a lot of the litigation that's pending now, we've had some kind of high profile, big top of the marquee litigation kind of on procedural rules in the past year before the Supreme Court. And I think that we're going to continue to see Supreme Court, courts of appeals really weigh in on a lot of issues.
One of the laws that NGOs and individuals can sue the government is the National Environmental Policy Act. Like, do you anticipate an increase of NEPA claims during the Trump administration?
I think it's likely, maybe not. So NEPA litigation involves legal challenges under the statute called NEPA, which requires federal agencies to assess environmental impacts of proposed actions. So litigation under NEPA typically comes when you see a stakeholder like an environmental group or an affected community believes that an agency failed to comply with NEPA procedures. So you just like in other citizen suits, you see a lawsuit getting filed in federal court. It's often seeking review of an agency's environmental impact statement or environmental assessment. And plaintiffs oftentimes argue that agencies don't consider environmental consequences or alternatives. There's a lot of litigation in this area. The Supreme Court, I think last month, heard the 7-county infrastructure coalition case. And, what the subject matter of environmental law is changed. What people are focused on has changed, but the statutes have not changed. And people are increasingly pushing agencies like, I think that the 7-county case involves a surface transportation board, and people were pushing for them to factor in sort of environmental justice related concerns and a bunch of other concerns. And there's a real fight about what the statute requires in those cases and what agencies are sort of institutionally competent to do. And, we're in an era where we have an energy transition going on, and we have the rise of a bunch of industries like, you have AI, you have data centers getting constructed all over the place. And sort of we have an aging energy grid, so an electric grid, where the wires that go from facilities to consumers of energy they're not sort of adequate to sort of meet the demands. And that mirrors in every other kind of pipeline and everything else. So we have a ton of infrastructure that needs to get built and a lot of money, and there's a lot of interest in the investment community to help build infrastructure. But every time you cross a federal land, you oftentimes have to have one of these NEPA assessments. And yeah, absolutely, we're going to see litigation. And then also we're seeing some pretty significant litigation and some decision making out of places like the DC Circuit that questions even whether the NEPA regime itself is constructed. So the big case there is I think it's Marin. Got to look at my case names. The Marin Audubon Society versus FAA kind of questioned that's about a month ago now whether the White House Council on Environmental Quality even set up NEPA like the regulations themselves had any basis. So this stuff's going to continue. I think we're all going to learn a lot more about NEPA in the next 4 years, just based on where we are and based on kind of a whole lot of uncertainty.
So the government and I think the Audubon Society have asked the DC Circuit to hear that en banc, correct?
Correct.
And mostly because it was the issue wasn't really even before the court, which is something that Judge Srinivasan pointed out in his opinion from the court, and the issue was somewhat before the Supreme Court in the 7 counties infrastructure case. At least one amicus brought that up. Any thoughts from either of you about the 7 county infrastructure coalition argument in terms of how that case might come out and how it might affect environmental citizen suits?
Citizen suits, I think it's likely that the Supreme Court will decide that case in a way which somewhat narrows the broadest interpretations of what parties are able to consider, like what should be included in the NEPA assessment. The assessments, and we had lower court decisions which were starting to require parties to anticipate and think through things that were beyond the competence of the agencies, but also beyond almost in some sense human comprehension. People need to know if you're going to file for a permit, you need to know what documents you file kind of before you start submitting things. And letting agencies consistently kind of engage in perpetual whataboutism kind of years into a permitting process is frustrating for everybody involved. And it seems like the court may carve some of that back. That said, incomplete record. I've listened to the argument. I've looked at some of the amicus briefs. So we'll have to wait and see. But, this is an area that is going to be a hot button area for litigation for some time, for sure.
Brad, any thoughts on the 7 counties case or the Council of Environmental Quality issue in the DC Circuit case?
Nothing more that Mike hasn't addressed. I will say that these are political as much as they are legal at this point, and we're seeing decisions that it's hard to speculate on how they will decide it, other than maybe the decision going in, because it's we know where they want to go with it and how they're going to get there. We've seen in all areas of law some interesting legal rationalizations for what they wanted to do anyway. So I'll leave it there.
So speaking of the Supreme Court, the two of you have written recently about how 2 administrative law decisions could impact environmental citizen suits. Let's take them one at a time. Like, how might the Loper-Bright / Relentless decision impact citizen suits?
So Loper-Bright is a fascinating case, and it involves not citizen suits per se. Usually Loper-Bright comes up in a situation where the agency has made kind of a decision in a regulation, and it involves some aspect usually of the agency's competence. So the agency's trying to figure out, can we regulate a behavior and how should we do it? So over time, Loper-Bright is a new case, but the case before was Chevron versus National Resources Defense Council, which came from the 1980s. And in that case, they were trying to figure out the scope of the Clean Air Act. And the Supreme Court there constructed sort of analysis. First is, okay, does this fall within sort of the call of the statute? Is this within the agency's sort of core competence? And if so, is how the agency decided this reasonable? And if it was reasonable, the courts would just defer to the agency. So that was pretty at the time, it was viewed as kind of a relatively inconsequential decision. But over kind of the 40 years following, over the time, agencies started relying on deference a lot in a lot of circumstances, not just about statutory ambiguity, but also about their own regulations. And kind of the high watermark of that is you could be litigating against an agency in court, and all of a sudden they'd say, well, we never said this before, but we're going to say this in a brief. This is our position. We're entitled to deference. And that's a wild thing for business. It was a wild thing to litigate against. And over time, people started carving that back. So a few years ago, we got a decision in a case called Kaiser versus Wilkie, which involved whether an agency was entitled to deference in interpreting its own regulations. And in the court said sort of maybe yes, maybe no, but we need to look at context. So Lober Bright came about this year and involves sort of fishing monitors on boats and who had to pay for them. But what the court ended up deciding in that case is, look, we're going to give some respect to how an agency decides things, but like we did in Kaiser, we're going to look at the overall decision and we're going to give it respect, but not deference. So saying we are an agency, you need to defer to us no longer works. Kind of in the overall worldview, people kind of had priced this in. If you looked at Chevron stopped being cited by the Supreme Court kind of materially about 5 or 6 years ago. The Biden administration in their first 51 regulatory actions only cited Chevron deference 5 times. And in this Loper Bright case, the court overturned it and said, yeah, you get deference, but not respect. So how does this factor into citizen enforcement? Factors in a lot. And the reason was typically this distinction between whether you're enforcing the law or changing the law was something that parties who were sued in citizen suit cases relied on all the time. Brad and I had a case involving the scope of the Clean Water Act where an NGO submitted arguments in the court case that it had submitted to state regulators before and been rejected. In the court case, we pointed that out and said, look, this is a suit that they're trying to change the law, not enforce it, so not good enough. There's a real fear that if we're entitled to respect and not deference, a lot of sort of ideologically motivated NGOs are going to get what they always wanted, which is the opportunity to use sort of a single party enforcement action as a chance to change the law. And some of the involved environmental statutes, particularly RCRA, are broad. RCRA involves, lets parties sue under one provision if there's a chance that something may cause an imminent or substantial endangerment to the environment. And historically, NGOs use that provision to sue about anything that they wanted, right? This language clearly creates a statutory gap filler. And what you don't want is to have courts embrace it. And, you end up in a longer fight about a business process or a business operation with folks motivated either by ideology, their own attorney's fees on the other side. I mean, it's just a frustrating place in terms of the predictability that businesses need.
And I would add, it's not a unique thought that the end of deference is an earthquake in our industry and it's impacting everything we do. But we're already seeing how it goes the other way as well, where parties, who at one time could be strong-armed by the EPA into performing are saying, you don't get to make that decision anymore. Let's let a court tell me what to do. And so it's going to end up, as Mike says, there's going to be a lot of citizen suits for parties who are saying, I don't care about EPA anymore. They're off to the side now. I'm going to enforce this law in the way I want it enforced. We'll see if the courts adopt, their belief system on what they think the statute says, because I'm not sure that will match up either. The same parties that got rid of the deference aren't going to all of a sudden take the NGO's side on some of these enforcement issues. But I think there's going to be a lot of litigation over it.
So the second decision that you've written about that the Supreme Court came down with from its last term was the Corner Post decision, which deals with the statute of limitations for the cases against agencies on regulatory issues. Mike, can you talk a little bit about that and how that might affect the citizen suit environment?
Corner Post is sort of a decision that nobody saw coming. Statutes of limitations to challenge an agency action related to the time of the agency action, as opposed to when the agency action was felt by a particular plaintiff, felt in our world to be pretty settled law. But in the corner post case, which involved sort of interchange fees and the Federal Reserve, a group filed a challenge, and the challenge looked like it was headed to be time barred. And they went and found a new plaintiff that was a new company and said, hey, look at this new plaintiff. We're entitled to a new statute of limitations. And the Supreme Court ended up agreeing with them. So that's interesting. It's in the environmental space. On the surface, it doesn't have the biggest direct effect because most of the environmental statutes have statute of limitations which come from sort of the organic statutes themselves. They don't fall back to the default under the APA, like a lot of other things. The one exception there is the Endangered Species Act uses sort of the default time periods under the Administrative Procedure Act. But the concept that there is a Supreme Court decision that undercuts administrative finality, I think does potentially have sort of broader trends, and kind of emphasizing that just because saying, okay, we're not using the provisions of the APA here, Chevron actually wasn't sort of directly an APA decision either that led to Loper Bright, because the Clean Air Act has huge exceptions for the APA. So once you start undercutting administrative finality, which is sort of necessary to some degree for business certainty, it's likely to have a bleed over.
Another trend that you've written about, which is really a big and developing one, is how NGOs are coordinating with plaintiffs' lawyers and state and local government to advance their shared agendas. Can you give us some examples of areas where citizen suits are being combined with tort claims, or where tort claims or consumer protection claims are sort of acting as stand-ins for citizen suits? This is a pretty big one. So, Mike, if you wanted to go first, and then Brad, if you wanted to follow on with some thoughts as well.
So kind of there's sort of a simple case or a traditional case, and I'm going to let Brad talk about that. But so, Brad, why don't you talk about that first, and then I'll loop in sort of the bigger picture as you after you.
What are you referring to?
Citizen suits,
No,
like we faced in the San Francisco case, where you had tort claims stacked on RCRA claims.
Yeah. Oh, okay. Sorry. So I was thinking of I was going to be saying something different. So yeah, the use of tort claims here as a, I don't know, stand-in is the right word, but what we're talking about in San Francisco was property claims, basically, and the advocacy group here, all of the properties in a very nice area of San Francisco, where the parties wanted to have us buy their properties from them or pay them lots and lots of money because of historic contamination there, so they were using citizen supervisions because what is the damage in a tort claim when there is no so they tried to go about it through an environmental phase as opposed to the torts, because you need damage with tort. With environmental, you got the may, as Mike mentioned, may be an imminent and substantial endangerment. The thing I wanted to talk about, though, was earlier this week, even the states, the commissioners and the heads of state environmental groups are meeting to plan. What are they going to do? I'm aware, I think it was on Tuesday of this week, they had a large meeting. And one of the things that they're trying to do is, what do we do when the EPA is no longer allowed to enforce the law? And some of us have budgets. Some states have environmental budgets. Other states have no budgets or very small budgets that don't come from the federal government. So what happens when that funding is gone? And one of the things they're talking about is this exact thing here, using advocacy groups and the citizen suit provisions to continue their work, because these state level people obviously want to keep cleanups going, and they simply can't do it. I can tell you, during the first Trump administration, when you were dealing with EPA, they lost a lot of their power to do anything, and everything got slowed down and delayed. And now we're looking, the EPA people I talk to are telling me it's not even that things will get delayed. They may just be told no. So everything is going to move to the state level, and there's no money there in a lot of cases. So the states are going to be looking to these NGOs, and they're coming up with plans now, and they're having these meetings, and they're trying for group action, how they can coordinate these efforts with advocacy groups and amongst the state commissioners of, their own state EPAs and Department of Environmental Corrections to do this work. So that's going to be a big area in the next few years, and you'll see almost friendly citizen suits as between the state and these NGOs, because they just don't have the budgets to do the enforcement they want to be doing. So if these groups can get attorneys' fees for doing it themselves and enforcing that law, that's the way it's going to happen.
Just to emphasize that, and the groups that are doing this are going to use creative theories. Sometimes they're going to use statutory theories. Other times they're going to use, as you've indicated, Glenn, like consumer protection focused theories. We've seen a lot of actions that were filed by state attorney generals against generally or often petroleum-based companies about corporate disclosures or about advertising disclosures, and trying to seek to build a case for damages where they've had a lot more difficulty building a case for like damages to infrastructure. But the rise of climate-related regulation through tort action in state courts is clearly one of the big things to watch here. But we're also going to see some of this using probably the federal statutes too.
That was one of the areas that we should be watching, these so-called greenwashing claims that usually sort of sound in consumer protection. Is that an area to watch as well?
I think greenwashing kind of taking two ways. One, greenwashing focused on corporate securities, right? You could say our state pension plan holds these things and we're entitled as an investor. And then you also see greenwashing claims related to advertising disclosures. I think it's probably more likely the advertising disclosure claims will focus on issues like plastic, which overlap to some degree with kind of climate issues. And the other ones might be focused more on securities, but we'll see. We'll see. There's a whole lot of kind of litigation entrepreneurialism going on right now, where you have a lot of people who don't like how sort of the regulatory state is functioning, and they're using state courts to do it. And it's going to be interesting to watch, because sort of the federal courts, which even when they lean conservative, it said, hey, states are sort of independent laboratories of democracy, and they've been loath to wade in to kind of trod on kind of state tort actions. Sort of the leading case in that sort of space was National Pork Producers, which is only a term old, about California's regulation of pigs affecting the national market. But yeah, this is a space to watch.
Would it be fair to say also that if laws like California's to require disclosure of climate risks in securities filings, that's survived the first effort to overturn that? If that ends up surviving completely, do you see those kind of laws proliferating, especially if the SEC regulation is dropped or is defeated in court, and that creating more opportunities for litigation?
It's hard to predict. So the tough thing, when you're talking about California, you're talking about ESG-related regulations, which require people to report sort of scopes of emissions. So a company's direct emissions, a company's supplier's emissions, and you go up down the chain. So the terms people use are scope 1, scope 2, scope 3. California has some regulations. They've stayed the enforcement of those regulations by a year, but there's some expectation in California law that people are going to make a good effort in the first year. Okay, that's a thing. SEC has done similar things. Maybe it's the SEC's promulgated regulations were a little bit less ambitious than California's. Those are in the course of doing litigation, which of course features the Loper Bright case. That's another source of that. But you also have stuff coming out of Europe. And if you have a multinational company, you might be able to build a claim in the United States based on some disclosure in Europe. That's also there too. But it's a crazy space in the environment that we have policy entrepreneurialism coming from other countries that affects the United States. We have policy entrepreneurialism led by cities affecting the United States. And, it's challenging to figure out sort of what is fair and what is stable kind of in these circumstances.
If you have questions for either of our participants, please put them in the Q&A toolbar in the webinar box. One especially effective defense against citizen suits is one that we've already touched on a little bit, the challenge of statutory and or constitutional standing to sue. Mike, can you talk about some recent trends in the federal courts? Have there been good decisions that have come out, troubling decisions that come out recently? Any thoughts on that?
I think in the environmental context, let's start first with the environmental context. Standing is a super complicated area. So what does it mean? It's derived from Article 3 of the U.S. Constitution. It limits court jurisdiction to cases and controversies. And to establish standing here, a plaintiff's got to show three things: injury in fact, causation, and redressability. So those things are known. As Brad talked about, the environmental context, historically, standing has been relatively relaxed, in that somebody could be a member of an NGO and say, hey, this emission from this factory made me sad. Or I think that this pipeline you're building, which crosses federal land, which triggers a NEPA obligation, I think that just not enough stuff was included in that. And I'm affected by that. And courts generally had been pretty willing to let any cases come in court. That kind of hit a trend. And then there were a bunch of other cases in the past few years, kind of the lead one being the TransUnion case, which involved consumer kind of disclosures. 2021 case from Supreme Court said, hey, we're going to look and say you need to show a very particularized tie between the injury you're claiming and your statutory right to it. And people have tried to get TransUnion sort of imported into the environmental space. And they've been sort of frustrated by that. Sort of the lead case that we've been watching for many years now is a case out of the Fifth Circuit, Environmental Texas Citizen Lobby versus Exxon. We got a big decision, 170-page decision in that case yesterday. In that case, the group had like 6 citizen members who were close to an Exxon facility for a handful of days. And the Texas District Court let them proceed with 16,000 days of violations, leading to a pretty substantial penalty, even though their people could show no proof of being close to these facilities during those periods. So below in the district court, people were like, hey, this TransUnion case happened. You need to factor this in. The district court rejected that. It seemed like a panel of the Fifth Circuit wanted to let TransUnion govern, but felt that they were constrained because their precedent predated the TransUnion decision and they couldn't trump it themselves. So it went up on an en banc review, which delayed it a couple more years. And, yesterday we got 170-page exegesis from the court talking about how precedent works in American law. So we're back to what was before the district court, which a majority of the panel below didn't really think was the right law. But here we are, and now people are going to have to figure out whether they take this case as a vehicle to go to the Supreme Court, and I think it's going to be one to watch. But yeah, standing is an important thing, because if people have a policy dispute, which oftentimes sort of give rise to these cases, there's a place for policy disputes, and it's talking to your regulator and talking to your congressman. And congressmen need to know that laws need to be changed if they're not working for people. And a lot of our sort of key environmental statutes haven't changed much in the past few years. They came from the 1970s. They related to problems in the 1970s. They related to environmental understandings that we had in the 1970s. And Congress letting them exist without changing them has put a ton of pressure on courts to figure out what they mean in new contexts. And I don't think courts overall have done great with that. So, standing is how it's supposed to be sorted out. It's going to be interesting to see how this Fifth Circuit case proceeds from here.
Have either of you seen sort of forum or venue shopping based upon which circuit has more permissive standing standards? Certainly the Ninth Circuit's been one where you see a lot of citizen suits filed because some of their case law is more favorable than it is in other circuits. Would it be fair that there are certain circuits that are more popular to file citizen suits in than others?
I think that's right, but also, I mean, to some extent, there's less forum shopping with citizen suits because of the standing requirement, right? You have to be tied to the violation. So the location, I think part of the same reason that the Ninth Circuit is seen in a certain way is because of the people that live there. And so they're more apt to be in an environmental advocacy group. That's certainly where we see a lot of the citizen suits filed. So I'm not sure that you can forum shop all that often unless you're talking about a nationwide type policy of a company that is doing the same thing everywhere. But a lot of the citizen suits we see are very localized. It's about a specific sewer or a specific river, and at that point you just don't have the option. Mike.
I think that's right. The policy change litigation, you tend to see forum shopping, and the enforcement. I mean, oftentimes you're just tied to where an environmental release happened or where somebody wants to build something. NEPA can be a little bit of an exception to that because the decisions are potentially made in DC and there may be some forum selection issues there. But the kind of Clean Air Act, Clean Water Act, and RCRA, oftentimes plaintiffs are there or not and going to file or not, though there are pretty substantial differences in how different circuits look at environmental standing that don't actually always square with kind of perceived environmental agendas. Like the Seventh Circuit has much more restrictive standing for environmental claims that involve lakes than the Ninth Circuit does. And that's probably just a relic of history.
So you had mentioned environmental justice a little bit, like when you were answering one of the questions, and if the first Trump administration is any indication that that's probably not going to be a priority for the incoming administration, how is that going to, you think, going to play into the use of citizen suits with an environmental justice aspect to it?
I think that it's likely to occasion some more, but I don't think it's necessarily going to be for the reasons that one expects. The other thing that the Biden administration funded a lot in the course of its funding were actually NGO development. They were trying to struggle with the question of how do you get sort of meaningful feedback from communities about something happening? Like, what do these community groups want? And sort of from an equity perspective, getting open input from community groups is something that the government struggled with forever. And the Biden administration took a pretty unique way of attacking it. They gave a ton of money to groups and to try to build constituencies. And when that money goes away, you now have people who are organized and engaged in environmental issues, that they have pathways to community groups, but less funding. Is it likely we're going to see more sort of citizen suits coming out of those spaces? Absolutely. And, you know, there's sort of a good and bad reason for that. One, if people are more engaged with policy issues, I think that's great. But is this the best mechanism to channel their engagement to coherent policy? Probably not. Environmental justice itself, are we likely to see more citizen suits? I think we may see some. You have a lot of groups that have focused for the first time and organized, and you know, they're going to stay engaged in policies. And if they think the government's not listening, getting a lawyer or an NGO to sue for them, I think is a pretty likely outcome.
On that point, actually, I think what's interesting is, again, we were talking about friendly lawsuits earlier. I think this is another area of coordination with EPA in particular, which has always been a bottom-up organization where the lowest level project manager or attorney has an extremely high amount of power. And if they start something, it's really hard to stop it. So they're going to be getting potentially instructions from Washington on what to do and what not to do. But if they can either start processes that are hard to stop, or more likely work with NGOs to push their own agenda, I think we could see a lot of that actually happen.
So one final question, also related to the incoming Trump administration. If there is, as has been discussed, a possible exodus of federal agency personnel to the private sector, might you see a lot of the employees from EPA that have been dealing with a lot of these issues going to environmental groups or going to law firms that have a plaintiff orientation, and having them use their expertise to try to continue the work that they did while they were within the EPA?
Yes, there's sort of a guild of old regulators who are helping different groups. That group already exists. Sort of the other place that it factors in is, you look, the agencies have obligations under statutes to do things in particular periods of time. A classic example is acting on permit applications. And there are litigation. There's a case in Illinois now where a permit was applied for 10 years ago and the agency never acted. So under Illinois state law, that let a facility get constructed and it let a facility operate. But an NGO sues 12 years later and said, hey, you have the wrong kind of permit. So the other place that it could lead to sort of these things is if kind of separate apart, as a lawyer who works to help people build stuff, we need permits when we apply for them. But if you don't have people and agencies to act on permits, and it's a sort of super complicated, super technical subject, the works might gum up, and you may end up with litigation that way too. But the idea that the permitting regime in the United States needs to be clarified and kind of expedited, I think, is one that lots of folks can get behind.
Brad, any thoughts on that?
Oh, strongly agree. You saw me nodding my head along. Yes, no, it's a real pressing issue, and I'm not sure how much progress we'll make in the next 4 years, but it would help. It would help everyone if we could get there.
If there's a Venn diagram, it's the one issue that people on the far right and far left should be able to get together, because people want permits to understand how operations are worked, and people want permits so they can operate operations. And that's one we should all be able to do together.
Yeah,
especially in the clean energy space, where it would be interesting to see the environmental groups pushing back against that, despite the fact that that's what they've been pushing for years.
The same toolkit that was used against fossil fuels is now being deployed in clean energy, 100%. And environmental justice, that same toolkit, we can't get to a space where that means that everybody can NIMBY every project. That's not a healthy place for our country, because
that's where we are.
We have a need for a fuel transition to some degree, and you can question kind of how you get there. But everybody, we need to build power lines, we need to build pipelines, we need to build carbon sequestration infrastructure. All of it, the same permitting tools. It's broken and it's too slow.
As I said during the program we did last week on the 7 counties oral argument, or 2 weeks ago, just go to Loudoun County, Virginia, and look around at all the data centers that are being built, and wonder, where is all this power going to come from? And that's very, very potent image there.
28% of Virginia's electricity in the next 5 years will go to data centers. It's amazing.
Wow. It's unbelievable. Well, thank you, gentlemen, for joining us today. We're pleased to have you be our final speakers of the year. And thanks to everyone who's tuned in to our program this year and who did today as well. If you weren't able to catch the whole program, or you have someone you think you might want to have watch it, it'll be available later this afternoon as an on-demand file on our website. When you click off, there'll be a very brief survey if you don't mind taking that. Happy holidays to everyone. And again, thank you, Brad and Mike, for joining us today.
Thank you.
Thanks for having us.